It is an interesting point of Canadian law that it is illegal to publicly criticize a judge's decision. However, it is not illegal to criticize a judge. Kip Warner is the founder of the Canadian Society for the Advancement of Science in Public Policy. I last interviewed Kip in September. The CSASPP currently has 3 suits in the provincial courts against the BC government, and specifically against Bonnie Henry. Shortly after my last interview was released, Chief Justice Christopher Hinkson ruled against one of those suits on technical grounds. Subsequently, Kip became aware of a potential conflict of interest in the case. I say potential conflict of interest, as Kip is involved in the case and must be careful of how he expresses his concerns. I, however, am not involved, and I can say whatever I like about Justice Hinkson. I've looked at the evidence that Kip has provided, and in my admittedly unqualified opinion, there is not only a conflict of interest, but one of such import and scope that I felt it necessary to invite Kip back for an update so we could pass the details on to you. Kip, welcome back to the show.
Thank you for having me.
Now, before we get into the reason why I asked you to do this interview today, as I already explained in my introduction, that there's a potential conflict of interest here with one of the judges, I'd like to give people a very quick recap of CSASSP has been working on. We did discuss this at length in our last interview, which was released last September, but you've got 2 petitions on the go and a civic suit. Could you give a very brief recap of where we're at with those?
Sure. And so I just say CSASSP. That's what most people say, because the full name, Canadian Society for the Advancement of Science and Public Policy, is a bit of an earful and a mouthful. CSASSP has 3 suits, 2 of which are what are called petitions. It's not the same as like a list of signatures. It's a formal legal process. There is a kind of suit. And then we have a class proceeding as well, a proposed class proceeding. And so the 2 petitions, one of them challenges the injection passport. The other one challenges the injection mandates for healthcare workers here in BC. And the class action challenges the declaration of emergency and various other provincial health orders that flow from that. And it's brought on behalf of a class of, depending on how we define it, we're still refining the language of the class definitions, but we anticipate at this time probably over 3 million people will be part of it.
Right. And how has Bill 36 affected any of this?
It has and it hasn't. It's been something that, I get asked to do a lot of public speaking engagements and town halls. And this is something that has come up a lot. People ask us about Bill 36. And I think it is a terrible piece of legislation. I don't think it's as immediately as bad as people make it out to be. I also think that the plans for it preceded this government and the preceding one, possibly the one before that as well. I don't think that the thought genome, if you will, for it began inside of the provincial government. But having said that, it does raise concerns for us because the likelihood of that legislation having even been tabled, let alone being granted royal assent, probably would have been a lot lower had there not been a declaration of emergency. This whole lockdown and everything, all of that, I think was necessary in order to create sort of climate inside of our legislatures' minds in order to pass something like this, because I don't think they would have even thought about it as being necessary if there hadn't been this alleged pandemic.
Now, folks, I don't want to get Kip going into the details of all this because we covered this in our last interview. You will find the link to that interview directly beneath this one on our websites. So if you want to watch that previous interview with Kip that was released last September, where he'll give you the details on those petitions and that civic case, just go and watch that one. It's about a half an hour long. What I do want to get into, Kip, is you sent me some information about a week ago, and thank you very much for your rapid response in consenting to this interview, where we have a potential conflict of interest. Now, unfortunately, just because of the way things tend to flow, it was only a few days after we posted that first interview that you were informed that the judge for one of the petitions had rejected it. And it says here in your article, very much on just technical grounds. But now this same judge is in a potential conflict of interest. Would you please explain what that conflict of interest could be?
Sure. And so the petition that he was presiding over, the Chief Justice, was the one that was concerned with the injection passport. And so he's not just a judge. He's the Chief Justice. So each of the different courts in Canada, provincial courts of general jurisdiction, Supreme Court of Canada, Court of Appeal, Federal Court, Federal Court of Appeal, all of them, they all have a senior judge that is sort of administers the courts, and he's the boss. That's what the Chief Justice is. And so in the Supreme Court of British Columbia, which is our main court of general jurisdiction here in BC, the Chief Justice is Chief Justice Christopher Hinkson. And he was the one who presided over that petition. And we came to learn of what appears to be a serious conflict of interest that was not disclosed to us at the time that he was hearing that petition. It's quite normal for judges where they do perceive potential conflict of interest to offer to recuse themselves. And they do that so that as the proceeding unfolds, one side can't later say, well, we found out about this conflict of interest 3 months after. Rather, you made decisions that are clearly biased 3 months after you told us that you could have recused yourself, and you didn't. And so that's why they let everyone know off the bat if there is a potential conflict of interest. And I've seen this in provincial court, Supreme Court, where things of much smaller and lesser degree of significance, if any significance at all, are disclosed. For example, if a judge is presiding over some strata dispute, and I saw a case where the judge had been using the gym in that building because they live around there, and they recused themselves from it, even though it didn't really have any bearing, I think, on the contested issues. The judge did that, and that was for something that's really not important. In this situation, this is a lot more significant, as you've noticed.
What is the nature of this potential conflict of interest? Could you please explain the details?
Yeah. So in 1943, there was a nonprofit called Vancouver Foundation, which was created by our parliament, the Vancouver Foundation Act. And that piece of legislation created this nonprofit, which had an endowment then of, I think it was a little over $100,000, which might not have seemed like a lot of money today. But back then in 1943, that was a lot of money. And since then, it's blossomed $2 billion trust fund. That money was to be used as set out in the legislation, basically for various philanthropic causes, charities, nonprofits, whatever you can imagine. And so sitting on the board of directors, according to the legislation, is the Chief Justice of the Supreme Court of British Columbia. And then there's also someone appointed, I believe, from United Way, an accountant, and a lawyer, and is anybody else who they want to appoint. But those are the core required people. And the Chief Justice is a title, right? And so periodically, who owns that title will change over time. But I believe our current Chief Justice has been in that office since, I think it was 2011, 2013, somewhere around then. So he's been there for quite a while. And that foundation is a concern to us for a number of reasons. The nonprofit has at least 3 areas of concern for us. And these all flow from the underlying fact that the Chief Justice sits on the board of directors. Number one is the principal, the consolidated trust fund that they sit on, has to be invested in something in order to generate dividends. For those who have some experience in investments and managing portfolios, this is a really common thing. And so that $1.2 billion is invested in all kinds of things. In fact, so many things, it's very difficult for any one person to know at any given time where it's all invested. But we do know that part of it is invested in ETFs, exchange traded funds. I forgot what it was, what it's called. But basically, it's a bunch of different types of securities, stock in companies, publicly traded companies. These could be like blue chip companies like Pepsi and IBM and whatever. But it's pretty unusual for those to not include pharmaceutical companies. The standard portfolios will include like energy, real estate, tech. Pharma is always in there. So it would be unusual for it to not be in there unless someone explicitly gave instructions to the contrary. And normally In a situation like this, they would just delegate to the portfolio managers at major financial institutions to determine what was best for it. They might give them guidelines, like we don't want to invest in gambling or pornography or oil or whatever. In this case, I didn't see any restrictions that prevented them from investing in pharma. So that's the one issue right there, is where are they investing in? Second issue is, where are the proceeds of those investments, the dividends paid out? How are they distributed? And according to the Vancouver Foundation Act, the board of directors is responsible for determining that, making decisions. They might delegate, and probably do, to subordinates, but ultimately the decision rests with them whether or not to do that or not. And so we found that, in a nutshell, I think it's a little over $2 million that we were able to track has flowed from the Vancouver Foundation to Dr. Bonnie Henry's employer through an intermediary. This has been going on for quite some time. And the problem there is that Dr. Henry is named as a respondent, the person who we're suing, in two of our petitions. Actually, all three of our proceedings named Dr. Henry, but in particular, the one that the Chief Justice was presiding on, no different there too. She was the respondent in that case. And so he didn't disclose that. And that's a concern. So it's not just PHSA that she works for that was receiving money, but there was a lot of organizations, the BC CDC, which has set up a foundation, even the BC Civil Liberties Association, which we all remember didn't really participate much in any constructive way in the debate, which is something that you'd normally expect a civil liberties organization to do, especially when it's staffed by lawyers, constitutional implications and so on of these mandates. They were largely mute throughout the alleged pandemic. And we later learned that there had been money donated to them as well, including a nonprofit CBC has set up, although it's not very much money to them. But there's a lot of problematic destinations for the money. So that's issue number two. The third issue is actually, notwithstanding where they invest the money and where they distribute it, what are their other political activities? And we can find through the provincial website on I think it's the lobbyist registry, you can see the type of activities that they've been doing. And for every fiscal year that we could find, almost always there were some sort of COVID-19 related policy objectives that they were trying to achieve, specifically with the provincial government. And it's documented. So it's not unusual for a nonprofit to do what they like, to donate to whomever they choose. But it is unusual for the Chief Justice of the Supreme Court of British Columbia to preside over a $1.2 billion trust fund and then engage in all those activities. Just putting aside CSASPP activities, there are so many potential conflicts of interest here. Like, for example, the Supreme Court of British Columbia presides over all kinds of criminal matters too. Those aren't just in provincial court. The more serious ones are heard in Supreme Court, which means that this judge, who is also sending money to various policing charities, is making decisions on whether to send someone to jail or not. Some people who have had run-ins with the criminal justice system, thankfully I haven't, they may have an issue with that. So I think there's quite a bit of material for people to look at and determine on their own whether they think there's an issue here. And I think any reasonable person that looks at the records that we have would come to that conclusion, that there's at the very least, a very reasonable basis for the appearance of conflict of interest.
All right. So let me see if I can sum all of this up, Kip, and please correct me if I get any of this wrong. I'm going to try to connect about 5 different dots here for our viewers in one summary. First, this justice isn't just any judge. He's the Chief Justice in the province of BC. He's the top judge in the province. Second, he rejected your petition on technical grounds, and this petition was specifically for the coerced mandates of vaccination for healthcare workers, correct?
Sorry, not healthcare workers, for everyone, the injection passport.
My point is, this has very broad-reaching connotations in terms of the number of people who could be affected by this petition being rejected, in that they're trying to force everybody in the province, basically, to be coerced into repeated injections. So now we've got this Chief Justice, and we found out that he is sitting on a very small board of a $1.2 billion trust that is, probably invested in pharmaceuticals. Now, even if the judge himself does not financially benefit. It's his job as part of the board to administrate that trust in such a way that it will grow. And so there's conflict of interest number one. If he's blocking this petition, then he is working basically in his own favor as a member of that board to expand that trust. Because if they're invested in pharmaceuticals, which they almost certainly are, then obviously the trust is going to benefit from that decision. So that's conflict number one. Conflict number two, we've got money flowing to the various health authorities in the province, which are being affected by Bill 36, which, and I realize that you said you're not that concerned about that, but I am, because it's setting them up basically as dictators to all government workers in the province, not just health workers, all government workers, saying, you're going to take your shots when we tell you to take your shots, or you're not just going to lose your job, you're going to lose your license. So there's conflict number two. Okay, and then conflict number three, you've got the lobbying activities where this same judge is involved in other things that this money might get used for in a province that's trying to mandate these shots for pretty much everybody, because you're in this case involved in it. You can't come right out and say this is a conflict of interest, but I can, and I can't see how anybody, and by the way, folks, once again, if you go to our website, you'll find the link to the article on COVID Constitutional Challenge BC.ca, which explains all the details of this, and it's very well written, very detailed. I personally can't see how this is anything but not just a conflict of interest. This is a major conflict of interest.
I think that the way that they will spin it, and I'm sure their PR people in the foundation are already brainstorming how to deal with this. I suspect that what they're going to do is say, well, it's not a conflict because the judge's responsibilities are determined by statute. And there is a statute that says he's required to sit on this board of directors. In fact, he doesn't have a choice. He's not paid. He's mandated to do it, which is partially true. He doesn't actually have to. He can appoint somebody else who's also a judge. But I don't think that for me, I'm not fully satisfied with that explanation. And I think most people in a country like Canada would have an issue with, even if the law did permit such a thing. There's political implications. I think most people would find that such an arrangement unsavory. Having a judge, regardless of your politics, writing checks to people across the province, not just across the province. I mean, they were sending money to Toronto, to Harvard, I mean, like all over the place. And no one person should have that much influence, because even if your intentions are benign, there's unintended or perhaps intended consequence of acquiring influence the country. And that's not something that a judge is supposed to be involved in.
And so let's apply a little bit of logic here. Let's assume that the Chief Justice is under scenario A. Let's say that he's actually a good guy. He's trying to do his job. He's not using his position on that board for nefarious purposes. Okay, if that's the case, and you already pointed out, he's been in this position for about a decade now, should he not have raised that flag that says that just the appearance of conflict of interest is not something that they should allow to happen under their own rules? And so he should have raised the flag and either, as you said, found someone else to sit on that board or recused himself from the case. But he didn't do that. Well, there's no possible way he's ignorant of the conflict because he's been on this board for a decade. And I think it's very significant that when this was revealed, it didn't come from the judge. You got a tip from somebody else.
Yeah, and that is a bit shocking that it took 80 years in a small little nonprofit to make a stink about this. Yeah, it shouldn't take 80 years in a small little nonprofit to make an issue of this, but it has. I think that explains how this could go for so long unchecked. See, it preceded the Chief Justice. I mean, like, it was before he was even born that this was a standard arrangement since 1943. People might ask, well, how is it possible that something like this could happen? But they have to appreciate that the world was a very different place in 1943. In the 100 years that led up to that, it was not controversial for one person to hold absolute power over millions of people. That was what a monarchy did. And so this idea of that much consolidated power, it wasn't as controversial as it is today. I mean, these are sort of the residual artifacts of British Empire, which is what Canada is. And in 1943, I don't think anyone would have raised a stink about this. But today, you would probably have a hard time trying to get a piece of legislation passed like that. Another question people haven't asked is, why is it necessary for a judge to sit on that in the first place? Like, what is the qualifications of a judge that lend themselves well to that? Do they have a background in managing nonprofits or organizations? What is it that about a judge's qualifications that makes them suited to sit on the board of directors for a nonprofit of this nature?
But I think the salient point that we have to stick to is we have a person, and you made that reference, yeah, back in 1943, one person having that kind of power wasn't that unusual. But today, we're supposed to be trying to avoid that kind of thing. Because what we've got right now is a situation where the top judge in BC is both in a position to kill your petitions while sitting on a board that funds the people who would benefit from killing those petitions. And I think it's that simple, really.
On the subject of killing, I mean, our government has killed other people in other countries because they've accused them of having judiciaries that aren't independent, and carpet bombed Iraqis, carpet bombed Syrians and Libyans, and for allegedly having these kinds of political institutions. So I don't see how, if it's not right to have that being done in a third world country, how it could be acceptable in a first world liberal democracy.
So I think I have to finish this interview, since you've raised that point, with this question, Kip, because you are embroiled in this legal fight for the rights of the people of BC. And folks, if you watch the first interview, you'll find out Kip's not a lawyer. He's unusual a person to be in his position as I am to be in the position I'm in. Neither of us come from a background that would have led us here. But here we are. And you've made this observation that, yeah, the US and the UN, with Canada's involvement, we have carpet bombed countries that are rife with political corruption or accused of it. And here we are sitting on this exact same thing happening. And this is hardly the only example of this kind of corruption in our country right now. Are you hopeful that we're going to find a way out of this, that there's going to be a legal resolution, that there's going to be justice for this, and that we're going to bring back some checks and balances that actually have teeth in them? Because clearly this doesn't.
As much as people pursue this issue in public forum and the media covers it, and there's more discussion about it, especially in academic circles, I think that will be a very good thing. And that's the security right there. And I think through that, with enough work, there'll be political pressure to make reforms. But I don't think that judge is going to go kindly of his own volition. I think that the Attorney General or somebody's going to have to step and say, and this isn't the first time I've seen stuff like that happen. He, or it's now she, has had to clean up an institution that predated their office by a long time. It just wasn't a priority until it became a public issue. And I think in this case, there's a good chance that he will have to recuse himself either from foundation or from being a judge. But we know that if the Iranian government, if the Ayatollah had put judge administering a trust account that was sending money to Hezbollah or Hamas or the Iranian Revolutionary Guard or something like that, that's all we'd be hearing about on the news. It's all we'd be hearing about is a scandal like of that portion. So I don't think that if you're serious about justice, then the same rules have to apply everywhere. You can't have a certain group, select group of privileged people, which is really what the Vancouver Foundation Act describes. I mean, what is it that's so unique about a chartered accountant and two people who represent lawyers and United Way? I mean, these are influential people in their industries, and they have considerable influence over social, political, and economic affairs of the country.
No, I'd said that was my last question. I lied. I have one more. Because it does say in your article here that you have filed an appeal on this, and that appeal will be heard in October of this year. But what about the other petition on your civic case? Can you give us an update on those?
Yes, we already had actually really strong, solid basis for an appeal, even without the recent revelations. I mean, we have serious grounds for an appeal already, in that he made some, in my view, fatal mistakes in his understanding of the law. He didn't get into the Section 7 analysis, which is right to life, liberty, and the pursuit of the security of the person. And anytime there's the threat of incarceration, the courts are required to go into a charter analysis, because sometimes it's justified. Your charter rights sometimes do need to be suspended. Like if you just murdered someone, then your charter rights are going to be suspended and thrown in jail, right? You still have some of them, But there are situations where they can be preempted. And so the courts always have to contemplate, is it justified or not? And he didn't do that in this case because his position was that there was no threat of incarceration if you didn't comply with the requirements of the injection passport. And as it turns out, there is a threat of incarceration. If you buried in the public health orders, if you follow the legislation, the various trail that I put on our website, you can see it for yourself that there's not just a threat of a fine, it also includes incarceration too. That right there is an error of law, and the Court of Appeal will be required, in my view, to reconsider that. They may not overturn his decision, but there's a good chance that they'll at least remit it back to the Supreme Court for fresh consideration under a different judge. That's the injection passport, the status of that petition and its corresponding appeal. Then we also have the other petition that's challenging the injection mandates for healthcare workers. And there were some procedural delays that were beyond my control that some other parties took an interest in this type of litigation and brought their own parallel proceedings, and that slowed things down. But regardless, we're doing what we can to move that forward. It will be heard on its merits before Justice Koval, who I think is a good judge. He seems to be listening. He's a bit frustrated as well with the delays, and that becomes quite apparent just by watching what goes on in court. That's the injection mandate for healthcare workers petition. And then the class proceeding, everything is still steamrolling ahead. Everyone knows that's our feature attraction, where we have most of our eggs in that basket. And that will be proceeding on the 24th of April. So everyone by now has probably seen the hearing footage for the last 5 days of the certification hearing, and there'll be an additional 5 days that will resume in April. We were hoping that we would get it all done in the 5 days that we previously had allocated in December. We ended up using more time, and as a result, or reconcile everyone's calendars, the earliest that we could all get back was end of April. I would have liked to have been in there sooner. I think there is at least one small benefit to the delay, and that is the environment for critical reflection on what we've all just lived through for the last few years is more accommodating now than I think it was a year and a half ago. So that's one good thing about delays, but it's something that I'd prefer to avoid.
And the civic suit?
So the civic suit, I think that's what you're talking about. That's the class actions and
Okay.
what's called a notice of civil claim. I know the terminology can be a bit confusing, but so with the class action, which challenges the declaration of emergency, among other things. We have the petition that is currently being appealed right now. That's regarding the injection passport. Chief Justice Hinkson was presiding over that. And then we have the injection mandates for the healthcare workers.
Kip, thank you very much for taking on this fight on behalf of everybody in BC and, in fact, everybody in Canada, because when legal precedents are established in a province, they tend to carry across the country. And thank you also for keeping me up to date so that I can let our viewers know what's going on.
Yeah, on behalf of the team, we thank you for hosting us again. And whenever you want us back, just let us know. I'm sure once we get back to certification, there'll be a lot more to talk about.
Well, you bet. You just keep me posted, and we will keep the viewers posted on what's happening.